Good morning. May it please the court. My name is Hoyt Samples of the Chattanooga Bar.
Mr. Samples, wait a second before we start, before Mr. Hibner calls the case. This is being done on YouTube, so we'll need to call the case first. And I wanted to mention to y'all before we start that if we don't anticipate any technical problems, but if any should arise on anybody's situation, just relax. We'll we'll take a pause and work through it. Mr. Hibner, call the case, please.
Priority Waste Service, Inc. et al. Versus Santek Environmental, LLC et al.
We'll hear from the appellant.
Thank you, Your Honor. May it please the court. I'm Hoyt Samples of the Chattanooga Bar, and I represent the plaintiffs, Priority Waste Service and Steve Frakes, doing business as Industrial Refuse. The reason that we are here today is because the trial court improvidently admitted a, quote, notice of filing, which contained 7 exhibits submitted in connection with the defendant's motion 12.06 to dismiss. The court considered those exhibits, which mainly consisted of snippets of minutes of the Bradley County Commission meeting, in deciding to dismiss this case. Because this is a Rule 12.026 motion, matters outside of the pleadings are not to be considered, and if they are, then the motion is converted into a summary judgment. If it is a summary judgment, then we are entitled to take discovery concerning the issues raised in the pleadings, including but not limited to the completeness of the minutes, the textual context of the minutes. And we would point out that even if this was in a Rule 56 environment, the quote notice of pleadings would not have been admissible. There's been no authentication of that document. There is no admissibility of that document. We therefore believe that clearly the court should not have considered these matters outside the pleadings. Fundamentally, this is a case about a municipal landfill, the Bradley County landfill. We would not be here if this was a privately owned landfill, but there are special statutes, 2 of which in particular, which I'll refer to as the Landfill Statute and the Tipping Fee Statute, which are applicable to municipalities. In this case, the parties, that is industrial waste and priority waste, are direct competitors with Santek. Santek, however, has entered into a contract with Bradley County to manage the landfill. In other words, our clients pick up garbage, they sort it, and then they deliver it. In Santek's case, they deliver it to the landfill. Under their agreement, they have complete control over the pricing per ton, called the tipping fee in the industry, of what is to be brought to the landfill. And while Santek is free to charge itself little or nothing, my clients have been quoted as much as $50 a ton. In fact, the city of Chattanooga, even though it has its own landfill, uses the Bradley County landfill through Santek because of Santek's advantageous ability to manipulate the prices. It is our position that Bradley County cannot abrogate its responsibilities under the Landfill Statute or the Tipping Fee Statute. We have no quarrel with the ability of the county to enter into a contract for the management of the landfill, but they cannot abrogate their responsibility by giving that to an independent contractor. Once an independent contractor assumes a role of a governmental entity, in this case, Bradley County, they step into their shoes. And there is no dispute but that the landfill statute and the tipping fee statutes are not being complied with. In other words, the landfill statute requires compliance with Financial Accounting Standard Board number 18 as developed by the Comptroller of the Currency. The reason for that is you must take into account the cost of the landfill and the cost of closing the landfill. All municipalities are required to adhere to that utilize a landfill. In this
Counsel, excuse me for interrupting. Do the statutes create a private right of action?
Your Honor, we believe that they do. And the reason that they do is if you see no exception in the statute, as you do in many statutes, for instance, a consumer product statute that says there is no private cause of action. The question of standing is an important one and very much related to private cause of action. And we believe the case law is clear that you look at whether or not the party is directly affected and would it benefit by the relief being granted. In this case, if the county and Santek are required to abide by these two statutes, it will establish a level playing field so that my clients can compete and provide competitive services, not only to the citizens of Bradley County, but to other counties as well. So we do believe that there is a private cause of action because we are directly affected and because it has an impact upon our remedy. The tipping fee statute, it uses the permissive term, the county may set the amount of the tipping fee. The landfill statute uses the mandatory term shall. Those statutes need to be read in para materia. That is, they are both related to the same object, the same purpose. And we've noted that Judge Franks and many others have noted that the word may can many times be construed as mandatory. And we believe in this case, the word should be mandatory because otherwise the statutes would be null and void and of no effect. And we believe that the statutory scheme is that statutes should be read together and should be upheld wherever possible. That is, when you look at the statutes, you will see very specific criteria about what a county may and may not do. It does not give them the right to abrogate that responsibility, although it could have. It did not. It is silent on that issue to a private third party. In essence, Bradley County knows virtually nothing about the operation of its own landfill other than it gets a check from Santek periodically. In fact, the residents of Bradley County, we believe, and our discovery will show, are paying much more to use their own landfill than Santek is paying because it sets its own tipping fee. When it comes to the question of standing, let me come back to Judge Frierson's question because that is an important one. And I would point out that it is an amorphous concept at times. It is a judicially created doctrine, but I think the heart of the issue is, does the party affected, in this case, my clients, do these statutes affect them in such a way that given relief from them would benefit? And the answer is clearly yes. The other question that needs to be posed, if we cannot bring this cause of action, then how would these statutes ever be enforced? We brought to the court's attention a case involving another landfill where this court upheld the ability of another county to enforce the provisions of these statutes. We think that we are in at least as good of a position as another county, but we are in fact more particularly directed.
Counsel,
yes,
sorry. Are you saying that, in fact, that if you have standing, that's sufficient to show that it created a private right of action? I mean, or are they two separate issues?
Well, I think they're intertwined, Judge Sweeney. It's difficult to find cases that don't talk about both of those issues within the same context. Again, there's no statutory exclusion for a private cause of action. And in determining whether there is a private cause of action, we believe the case law suggests that you look at the effect on the parties. Now, we have said that Santek has basically taken over a public function, and they've cited some cases otherwise. However, in those cases, those are easily distinguishable because there is nothing akin to a municipality abrogating its responsibility under multiple statutes to escape the responsibility of these two very highly relevant and applicable statutes. And I come back again to the question, if not us, who? Who can enforce these statutes? And if they are not enforceable by anyone, then there's no reason to have the statute, and therefore they would be null and void, and the law abhors a vacuum. So we believe we are the logical people to bring this claim, and we believe that we are entitled to explore these issues in discovery with respect to the issue of these resolutions which have been adopted. The cases cited by the defendants in opposition to our position are all cases dealing with, for instance, child support guidelines, which can be judicially noticed. We also have seen cases where they cited a rule of evidence. Those are all admissible. In this case, which is different than anything that Santek has, we dispute not only the authenticity, but the meaning, and you will read the snippets which have been attached in our brief, and you will see that they are internally inconsistent. That is a very important statute, because if this has not been properly approved by the Bradley County Commission, then this contract is void ab initio. Does the court have any other questions?
I hear none. You have your time for rebuttal, counsel. We'll hear from the appellee.
Please the court. My name is Crystal Freiberg, and I'm the county attorney for Bradley County. I have a few.
Excuse me. You and the defendant, the appellees have divided their time correctly.
That is correct, Your Honor.
All right, I see. Go ahead. I'm sorry. Go ahead.
I have a few points I'd like to make, and then I will share my remaining time with Mr. Dietz. First, Bradley County enjoys many benefits from this long-time contract that it has with Santek. These benefits include, but aren't limited to, Santek assumes all responsibilities and liabilities for the operation of the landfill. Per the contract, Bradley County bears no financial risk for the landfill, and only Santek is at risk if the landfill's expenses exceed its revenues. Santek also assumed the cost and responsibilities of expanding the landfill throughout the term of the contract. To meet the need for additional capacity, which is a very important concern for Bradley County, Santek acquired and now owns a significant portion of the property that's permitted by the state to be used for this landfill. Santek also pays Bradley County a host fee based on the tonnage of waste received at the landfill, providing Bradley County with a steady stream of income for solid waste expense purposes. Once the landfill is filled to capacity, Santek will be financially responsible for the closure of the landfill and the cost of post-closure care, which means monitoring this landfill for 30 years after its closure. And Bradley County receives reliable waste disposal services to all Bradley County residents who can take advantage of these established tipping fees. Bradley County did have the authority to enter into this contract with Santek, and the contract was properly executed and properly authorized. In 1992, Bradley County formed the Bradley County Sanitation Board pursuant to Tennessee Code Annotated 5-19-104 as part of its broad powers that is granted to it under Title 5, Chapter 19 of the Tennessee Code to oversee and provide for solid waste disposal services for a county. Bradley County delegated this authority to manage the Bradley County's waste to this board. In 1999, Bradley County, acting through this board, entered into the amended and restated sanitary landfill operation agreement with Santek that's the subject of this litigation. This contract significantly expanded Santek's responsibilities with respect to the landfill. Both Bradley County and the
I'm sorry for interrupting you. I just wanted to ask, who is responsible for making sure that Santek complies with the various financial and accounting statutory requirements?
Well, it is our position that Santek is not covered by, because it's a private entity, the provisions that are cited by Mr. Samples. Now, in the contract, the county does have the right to review their financials. We do get monthly reports from them. And the county, through the mayor's office, does monitor the contract to make sure that Santek is complying with its terms. However, the governmental accounting that he references is not done by Santek because they're a private entity.
Okay.
In 1999, Bradley County, acting through the board, entered into the amended agreement. And as I said, that was properly approved. On November the 1st, 1999, the Bradley County Commission passed a resolution to authorize the Sanitation Board to enter into the 1999 agreement. Then on December the 6th, 1999, the County Commission passed a resolution to authorize the county executive, which is now known as the county mayor, to sign the 1999 agreement. The November 1st, 1999 resolution is certified. This contract was amended 3 times after that. The 1999 contract and the 3 amendments were all attached as exhibits to the amended complaint. The resolutions approving all these amendments were all submitted as exhibits to the brief that I signed as county attorney, vouching for their authenticity. This binding contract.
Counsel, let me ask you that before your time runs out.
Sure.
What's your position as to whether or not there exists a private right of action under these statutes?
Yes, Your Honor. It is absolutely our position that there is no private right of action. That is what the court held, and it is not in, because there is no private right established in the statute. The absence of it suggests that there is not, and if there's not a specific statutory authority for it, there is not a private right of action.
All right.
Most importantly, I think in this case, we believe that this court should not open up the floodgates for claims like this. Bradley County validly entered into this agreement with Santek. Appellants are competitors of Santek. This court should not allow this case to go forward because doing so would open these floodgates for disgruntled competitors to sue a county, to sue contractual relationships, and upend these contracts that were negotiated and entered into between the county and private entities.
Counsel, I'm sorry, you've used your time that you've asked for.
Thank you very much.
Yeah, hear the other counsel. Go ahead, sir.
Thank you, and good morning. May it please the court, I'm Wally Dietz. I'm counsel for Santek. I have a private right of action standing issue. That's critically important because if there's no private right of action, if there's no standing, then all the other issues in this case are moot and the case is over, and the trial court properly dismissed the case before addressing any of the other issues that are raised on this appeal. Second, I'd like to address the Rule 12 versus Rule 56 motion and whether the trial court properly considered this under Rule 12 or whether he was obligated to consider it under Rule 56. And there's nothing in this record that converted this motion from a Rule 12 motion to a Rule 56 motion under Tennessee law. Third, I'd like to briefly address these statutes because there's no conflict and there is no private right of action, and there's no way to apply these statutes to the operation of Santek by their own express clear terms. So let's say that I am in the waste disposal business and I'm here in my home, Nashville, Tennessee. I've got a little business, I'm doing okay. And I decide, I want to go over to Sevier County and see if I can stir some business up there. And I go to Sevier County and I find the landfill operator and I get an agreement to quote me a tipping fee for how much it will cost me to drop garbage into the landfill. And I get that contract, we sign it, and then I come back, I never use it. I never use the landfill. I never get billed by the landfill. I never pay $1 to the landfill. So I don't have any damages. I don't have any injury, but yet I don't like that contract and I'd like to stir the pot. And so I go to Sevier County and I sue to set it aside, saying it violates all these statutes. Well, I should be thrown out of court because I don't have a dog in that fight. And that is exactly the case we have here. We have competitors who do not live in Bradley County. They don't pay taxes there. They don't own property there. Based on this record, they have never once used this landfill. They've never been billed. They've never paid $1 to use this landfill. They don't have any damages, and so they don't have any standing. Looking at the private right of action standing issue, first looking at the statute, the Solid Waste Disposal Act clearly does not provide for private rights of action. It's nowhere to be found in the statute. And in fact, there are other areas of the law in that act where there are enforcement mechanisms, but there's no private right of action. But for about 100 years now, the Tennessee Supreme Court has looked at what they call the zone of interests. Do these plaintiffs fall within the zone of interests that the statutes are intended to protect? Well, here, these plaintiffs are not in the zone of interest. The town of Carthage case, which they cite in their briefs, the town of Carthage sued Smith County. Carthage is the county seat. They didn't like the contract. They didn't like the tipping fees. They were using it, paying it. They didn't like it. And so they sued to set it aside. Of course they have standing. The plaintiffs also cite 2 competitive bid cases, Browning Ferris Industries cases, where the losing bidder had the right to go to court to seek redress to say there were irregularities in the bid process. Well, that's clearly established by law. Everybody knows that. There is not a single court decision these plaintiffs have cited that fits these facts, where strangers go into a county, they haven't paid any dollars, they don't have any damages, and they say, I don't like it, we're going to sue to set that aside. That's never happened in any reported decision in Tennessee. Second, the trial court properly addressed this as a Rule 12 motion. The amended contract attached as exhibits the contract itself, the 99 agreement, plus the 3 amendments. So they're in the record. They are part of the dispute. There's no doubt that they can be considered. They're in the record. The county and Santek filed exhibits, including resolutions documenting where the county approved entering into the contract. Those were attached and submitted to the court. And we believe they were properly considered by the court. And let's take, for the sake of argument, what if maybe they weren't? Even if they weren't properly admitted properly before the court on a Rule 12 motion, these parties still don't have standing. These statutes still don't create a right of action. The statutes themselves were not violated. It is certainly not reversible error. And that seems to be the linchpin of the appellant's argument here today.
Excuse me for interrupting, counsel. As I understand, in addition to any exhibits which were attached to the amended complaint, your client also filed a notice of filing that presented to the court additional documentation for the court to consider. Is that correct?
Yes, Your Honor, that's right. And that was in the record. And
did the court consider that in making its determination on a Rule 12 analysis?
They properly did. Yes, Your Honor. And the reason is there is an exception to the general rule. The general rule says that you cannot go outside the pleadings, but we have lots of case law in Tennessee saying that it is appropriate for the trial court to go outside the pleadings to take judicial notice of things that are public records. These resolutions are public records. They were submitted by the county attorney. They are public records. The Athena of SC case says that. We have 2 Court of Appeals cases we've cited in our brief where the moving party submitted documentation from what was on the government's website and said that comes into evidence. 2 cases say that's okay for Rule 12. And in the Western Express case, the moving party submitted a settlement agreement that resolved some of the claims that were at issue in the case, but it was not part of the complaint. And the Court of Appeals says, yes, that's okay. You can do it.
Excuse me for interrupting again. Did the court consider minutes of meetings?
I don't believe they did, but again, those minutes of Bradley County Commission meetings, those are public records, just like information on a website is a public record. So we're saying these are clearly public records, and they are valid to be considered. The Harvey case, which the plaintiffs cite, doesn't apply here. In that case, you had 3 government entities sued for flood damage. The county moved for summary judgment, and as part of that, submitted an expert report from an engineer about the flood damage. That's clearly not appropriate on a Rule 12 motion. That's expert testimony coming in. That's not permitted. The other 2 county entities moved to dismiss on Rule 12, and the court made a mistake and lumped all 3 together and dismissed all of the complaint, all of the claims, saying it relied on this engineering report. Well, that was fine for summary judgment, but not fine for the motions to dismiss. So Harvey doesn't help the plaintiffs here. We've not submitted affidavits or testimony. The Christenberry case, the plaintiffs cite for the proposition that documents outside the pleadings can't come in, when in fact that was not the holding in Christenberry. Judge Frierson wrote the opinion in Christenberry, and in that opinion, the court said that the reason the trial court erred was because the trial court failed to give the plaintiff the entire 1 year to cure the defect of issuing process and serving process. That was the reason. So Christenberry doesn't apply here. We just don't believe it's appropriate under these circumstances to convert this to a 56 motion when we are talking about government records submitted by the county attorney. But in any event, they're not critical because there's no standing. It doesn't matter. You don't need these resolutions to resolve the standing issue. And these statutes weren't violated. Very briefly, let me turn to the Solid Waste Disposal Act, which was passed 22 years after Title V. Title V created the right of the parties to enter into contracts with private parties. A county can do that. That's how this contract was set up. The Title 68 provisions added other provisions. Section 874 is an accounting statute that says counties, not private parties, counties have to comply with GAAP. And that provision is enforced by the Office of Comptroller of the Currency. Section 835 says counties may establish, not must, but may establish tipping fees. And they may establish tipping fees in addition to any fees charged under Title V. So Section 835 expressly incorporates Title V and says if the county wants to charge additional fees, it can. But it doesn't have to, and it doesn't have to set the fees, and here the county did not. So for all these reasons, we believe the trial court was correct, and we ask this court to affirm the judgment of the trial court. Thank you.
Thank you, counsel. We'll hear from the appellant rebuttal. Counsel, you need to unmute your computer.
Thank you, Your Honor. As a point of personal privilege, I'd just like to thank my counsel for being so professional, hard-fought, very intelligent, but very courteous. And after having practiced for more than 40 years, unfortunately, I don't see as much of that as I used to. Let me address these points very briefly. The issue of damages is very, very important. It's obvious what happens when Santek charges itself $0 for a tipping fee and charges my client $50 for a tipping fee. When contracts are bid to third parties, for instance, the city of Chattanooga, my client cannot be competitive because they are having to pay a $50 tipping fee. So obviously we have significant damages. The mechanism of approval of this contract is extremely important because the statute requires the contract to be negotiated by the county mayor and then approved by the Bradley County Commission. you will see in the snippets, and it's been cut and pasted, was provided to us, that did not occur. On their face, all we see are resolutions authorizing the county mayor to negotiate a contract, but we don't see that contract being brought back to the commission to be approved. And the reason that these are so inappropriate to be considered is, number one, we have no idea if this is the complete record. We don't know. We finally got what we received through public records, multiple public records requests, and then what we received appears to be incomplete, and we should be entitled to pursue that in discovery. And as I mentioned, there was, even if this had been a summary judgment motion, those items were not admissible. Judicial notice is only applicable where there's no contest. We're contesting not only the validity, but we're contesting the very language themselves because they're internally inconsistent. This is unlike any other case cited by the defendants where there has clearly been something a court could take judicial notice. None of that occurred in this case. And finally, the tipping fee and landfill fee statutes must be read together. If you do not read them together, then neither one of them means anything, and the legislation would fail of its own accord. Mr. Dietz is correct that the tipping fee uses the word may, but not the word shall as in the landfill statute, but it wouldn't make any sense unless it was mandatory. In addition, that statute requires the county, not a third party, to collect the tipping fee. It is undisputed that that is not being done in this case. And finally, with respect to the issue of standing, I would once again say the city of Carthage case where a county had the ability to challenge a landfill ordinance is very applicable. And lastly, if we do not have standing as a direct competitor and a direct interest in the outcome of this case, then no one does, and no one could enforce these statutes. Does the court have any additional questions?
I hear none.
Thank you very much.
Court, thanks to all counsel. We appreciate your briefs and your oral argument this morning. Mr. Hibner, if you will, please recess court until 11:30.
This honorable court is now in recess until 11:30 a.m.
Thank you.